we're doing legal liability. I don't want to talk about any of that. Oh, yes, I do. I want to talk about this, number 2. What is the difference between, we're on page 115. What is the difference between business failure, audit risk, business risk, right? Information risk, okay? What's business risk? It is the risk of failure of the business, bankruptcy. It's bankruptcy risk. What do people want to do that are using financial statements? Reduce bankruptcy risk. That's it. We are giving them information to reduce risk, right? What's information risk? The risk that the information is biased, false, right? Biased, false, whatever. Okay? It's not a faithful representation. Remember, that's not a faithful representation. Reliable. And then relevant too, right? So information risk is the information does not fairly present the financial risk to the company. All that's how. We know that. Okay? Business risk is the risk of bankruptcy. If you have good information, you reduce your risk of bankruptcy. Information risk is the risk that the information is not good. None. Okay? And then what is audit failure? Yeah, you give the wrong opinion. Audit failure is you gave an unqualified opinion when it wasn't justified, or you qualified when that wasn't justified. You could include disclaimer and adverse in that too, I suppose. Okay? That's audit failure, right? Okay? Who has that risk? Which is audit risk, by the way, right? Audit risk is the risk of audit failure. Okay? Who has that risk? The auditor does. That's the auditor's risk. We're not taking the business risk. If you want me to take your business risk, you must give me 100% of your returns. Right? That's my audit fee. Whatever you earn, I get, because if you lose, I have to pay, right? So I get all your returns. No, we're not going to do that. Nobody's going for that. So we're real clear about what our risk is. We're giving our opinion. You're taking the business risk. I'm not. Now, if I screw up my audit, I get to share in that business risk, don't I? If I give you, theoretically, if I do a really good audit, I don't have your business risk, right? Theoretically. But we know deep pockets idea. What do they mean by that, the deep pockets idea? Who has the money when there's a bankruptcy? Who's left that's holding money? The auditor, and I can think of one other group that does it. It's really integrally involved with the company, negotiating all their deals with them, writing up agreements. Lawyers. Who would you sue? A bunch of lawyers or a bunch of accountants? They have deep pockets too. They just don't get sued because they can defend themselves, and it's cheap for them to defend themselves. In fact, they win when we get sued because who do we hire? The attorneys, right? To protect us, okay, to defend us, okay? So this deep pockets idea, even though we did nothing wrong, we did a really good audit, make sure you document everything in your audit, so it means writing everything down, right? Doing those work papers, okay, collecting that evidence, you document that you collected the evidence. Because if you end up in court someday, you have to prove that you did a good audit, right? That's how you're going to defend yourself, okay? All right, anyway, so sure. So we need to know that. All right, primary terms, let's see, okay, liability-related defenses, yeah, we'll do all that stuff, okay. I don't think there is a slide that does what's on page 117. So let's take a look at that. I think it's, no, maybe it is. Maybe it's after this one. Let's do this first. Change legal environment. We're over on page 114. Audit professionals have a contractual responsibility with clients. Well, sure. Engagement letter. We always have an engagement letter. Later we'll talk about it. In the engagement letter, it says what we're going to do, it says what the client's going to do, it says what our engagement is. We actually tell them basically what our opinion's going to look like. What they're expected to do, what we're expected to do, and we both sign this engagement letter. We have a contract with the client. It's a contractual responsibility with the client. We are liable for negligence. There is ordinary and gross negligence. We need to know the difference. Okay? Ordinary negligence and gross negligence. And different penalties and different liabilities in each of those situations. And then the number of lawsuits and size of the rewards remain high. No kidding. When somebody loses their money, they look around for who to recover it, right? And we are the ones left with some money. Okay, so change legal environment. Okay, they did not show them, I don't think. Page 117. Here they are. Ordinary negligence, gross negligence, constructive fraud in table 5.1. You guys see that there? Read through that thing. Breach of contract, third-party beneficiary. What's ordinary negligence? Somebody put that in words for me. What's ordinary negligence?
What would you expect from someone else in similar circumstances?
negligence. I don't expect negligence. Do professional care is what I would think any competent professional would do. We exercise due professional care, which means what? Try like that. We do our very best, right? We work hard. Pay attention. What's ordinary negligence? Give me one word. We hope we don't get it, so we don't expect it. I like that. What's one word? You made a mistake. It's a mistake. That's it. That's a good way to think about it. You made a mistake. Do human beings make mistakes? Yes. Now, is a mistake still your responsibility? Yeah. You made a mistake. You screwed up. You set your scope wrong. You looked at a check, and it's a fraudulent signature, and you didn't realize it was. I mean, you made a mistake. You should have caught it. You didn't catch it. You didn't take your sample properly. You thought you did, but you didn't, right? Okay, it's a mistake. Ordinary negligence, right? You didn't do adequate training, and you thought you had. Notice I keep saying you thought you had. You thought you did a good job. You tried. You worked really hard, and you made a mistake. We're still liable. That's ordinary negligence, okay? You can be liable for ordinary negligence, right? You're driving your car. And you think you're paying attention, but you look away. You run over somebody. You're liable, right? Should have been looking that direction. Or you were driving, obviously, okay? So it's kind of like that. What's gross negligence? More. It's got to be more, but it's gross. Gross is big, right? Gross negligence. What would that be? You did not try. Or you did so little, you might as well have not tried. You didn't look. You didn't collect the evidence. That's gross negligence. Guess what? You have more responsibility if you're grossly negligent. That make sense? Good. Huh? You put somebody on the job and they were clearly not qualified to do it, and they went ahead and did it. Gross negligence. Okay? You didn't audit a particular section. And it was clearly material. You had it, right? You didn't bother to audit it. And then you went ahead and signed a clean opinion. That's what a process. Everybody got it? Okay, so gross negligence, right? So you need to know these things and have the idea of them, and they'll ask you questions on them, real thin questions. So lack of even slight care, tantamount to reckless behavior that can be expected of a person. Some states do not distinguish between ordinary and gross. Oh, okay. So, you did what other auditors would have done with ordinary, but you just screwed up, huh? Okay? Absence of reasonable care, okay? You thought you did what other competent auditors did, but you had not. What's constructive fraud? This is an interesting one. Existence of extreme or unusual negligence even though there was no intent to deceive or do harm. Everybody hear that? You are so grossly negligent that you are party to the fraud. So somebody's embezzling, somebody's intentionally misstating their statements, ripping people off, right? You are party to the fraud because you didn't do appropriate audit procedures. Got it? So now you're fraudulent. So your gross negligence can be so bad that you're part of the fraud. That's constructive negligence in some states. Reckless in the case of an audit is present if the auditor, recklessness, in the case of an audit is present if the auditor knew an adequate audit was not done but still issued an opinion, even though they had no intention of deceiving the financial statement user, and they don't have to have profited from the fraud. They stole $100 million and they gave you nothing but your audit fee. If you didn't do a good audit, or you didn't try to do a good audit, right? You didn't even try. You're party to the fraud. You might as well at least take the money, huh? I'm kidding, right? Sorry. Anyway, and then fraud, of course, is where you had knowledge, okay, intent to deceive. Okay, go ahead.
What's the big difference between constructive and gross?
Constructive, you had no intention of defrauding anybody.
Gross.
Oh, in gross negligence? No, in gross negligence, you just did so little work that you didn't even try to do a good job, right? But constructive fraud would be there's a fraud committed, and now you are part of the fraud because of your gross negligence. Right? So gross negligence doesn't always go to constructive fraud, right? There has to be fraud perpetrated. You're part of it now. Even without knowing the fraud existed, you're part of it. Does that make sense? Okay. Versus fraud is, you're stealing from somebody and I know it and I did the clean thing. Now I'm party to the fraud. Okay.
So if there wasn't fraud, then it's gross negligence, but if there was fraud,
Yeah. If the gross negligence is bad enough that a court decides that it's constructive fraud, then it's constructive fraud. So it would be in a situation where you were grossly negligent and there was a fraud. but they wouldn't necessarily get connected. Does that make sense? It's really more of a legal determination if it's constructive fraud. But see, you can go to jail for constructive fraud. Gross negligence, you're probably just going to have to pay the losses. Constructive fraud, you're part of the fraud. You're not fraud. Takes a step to the source. Okay, but it wouldn't necessarily follow you, right? Even if there was a fraud and you were grossly negligent, you wouldn't necessarily be convicted for constructive fraud. Okay. Does that make sense? You don't have to get there. Sort of stages.
I don't understand what the difference is though, because I thought they're basically saying just constructive as if there was fraud involved and you're like, okay.
Yeah, but you don't necessarily have to be convicted of it. So you could be grossly negligent, there could be a fraud, and they don't connect you to the fraud, it's not a constructive fraud. The constructive fraud is you're going to be prosecuted because of your gross negligence. Okay? Versus just held liable. Any better? So it's levels. It's levels. Right? So it's not, the point is, it's not automatic that it's constructive fraud because it's gross negligence and there's a fraud. Okay? They'd have to actually prosecute you for it. Right? Okay.
So like examples, I give there, that audit firm, the Enron.
Mm-hmm. There's Arthur Anderson.
I understand.
Yeah.
So how would you describe their case? Are they like?
I don't have enough knowledge. Most people think it was gross negligence. Yeah, certainly ordinary negligence. They should have known. They should have found out what's going on. So it's at least ordinary negligence. With hindsight, I wasn't there. It's hard to say. If you talk to Pat Cass, who is a partner at Arthur Anderson, when the thing fell apart, he'd say it wasn't even ordinary negligence, much less gross negligence. It was all blown out of proportion. I'd say, yeah, it was ordinary negligence. I don't know if it goes to the point of gross, because I don't know how much work they did or didn't do. And I don't know how they managed not to find the things that were going on. But I think it's pretty suspect. So it's certainly ordinary negligence. Maybe it's gross negligence. Doesn't matter, they don't exist anymore. I doubt if it's constructive fraud. I don't think they knew about the fraud or anything like that, or even should have known about the fraud. So this is law, you guys. This is not cut and dry. Okay? We can get into any of these that way. It's awful. Then I'll try to answer some questions about it. Okay. Now, you guys did this in your business law class a bit, didn't you? Your two business law classes? 203 and 403? Don't remember. Brain dumps. Okay, anyway, all right. Now, breach of contract is what? Failure of one of the parties fails to live up to the contract. We don't deliver what we said, and they don't deliver what they said. It's breach of contract. That's all that is. What's a third-party beneficiary? This one's big. Yeah, it's somebody who is not the client and not us, not the auditor and not the client, but they what? They are going to directly rely upon the statement, right? And we are aware they are going to rely on it. So they're getting it for the banker. They're getting it for, another company to buy their company or something. We know why the audit's being done. Now they have more rights than just the general public because they're a third-party beneficiary, okay? And typically they're stipulated in the engagement letter who they are. Okay, on the next page, common law. What's common law? At table 5.1. What's common law, you guys? Okay, common law is precedent. You got it. Very good, right? States that develop their law through court decisions versus government statutes. Instead of a whole bunch of laws saying what you shall not do, right? We have court rulings about what was appropriate behavior, what was not appropriate behavior. It's not spelled out as much. What would you call it when it's all written down? That's statutory law. Most states in the U.S. are common law states. There's one that is not. Which one is that? Louisiana. Louisiana. Right? So it's not based on precedent. It's based on law. It's written down. Okay? And that doesn't mean we don't have laws written down, of course. Statutory laws passed by U.S. Congress, governmental units, and of course for the federal government, the Securities Act of 33 and 34, and now Sarbanes-Oxley, right? Okay, the 33 Act regulate? Remember this from intermediate? Initial public offerings, you bet. So it's the first time the company ever issues securities. What does the 34 Act regulate? A year later, they decided that wasn't enough. What does it regulate? Continuing, well, it is part of it. Yeah, it's insider trading type things. Yeah, but it's continuing reporting, right? Okay, establishes what? Annual reports, quarterly reports. So which one do you come in contact with more as a CPA working out there? 33 or 34 Act? Initial public offerings or continuing financial reporting? Obviously the 34 Act. Which one has more teeth in it, as in more criminal problems for an auditor if they screw up? Could be criminally prosecuted. And also more punitive damages, economic damages. Which one is tougher on us, the 33 or 34 Act? Where do we need more protection for the investor? Initial public offering. So the 33 Act has more teeth in it than the 34 Act. That makes sense? Right? Okay, one's continuing reporting. So usually only really big companies, big CPA firms, state CPA firms do initial public offerings. And they're going to be controlled by the 33 Act. Okay, by the way, when does the SEC get involved? Versus just state laws. When do the federal laws take effect instead of just the state laws, you're supposed to? When you have, what? Interstate commerce. Right? You sell your stock across state lines. Ben and Jerry's for a long time only issued stock, where are they from anyway? Somewhere up in the Northeast. Vermont or something? Ben and Jerry's ice cream. Anyway, they're up there, right? Now they wanted to get bigger and bigger and bigger, and as they got bigger, they started selling across state lines. And one of the reasons that they didn't go across state lines was they weren't regulated by the SEC. They were regulated by state laws, right? Far less complex, okay? Far less expensive, okay? But as soon as you sell stock, you know, on a U.S. stock exchange, right, a major stock exchange, if you're selling stock even in 2 states, right, in more than 1 state, you're now regulated by the SEC, okay? Public company. Anyway, good. So that's good stuff. Joint and several liability. This is a big one. What's that? As compared to separate proportional liability. What's joint and several? Yeah. So if the two of you are involved in some sort of fraudulent thing or just mistake, right? Both of you are involved. You're bankrupt. He's not. We can go after him for all of it. It's not half and half. Okay? That's all it is, joint and several. Okay? Jointly or individually, right? Okay? What is this proportionate liability, which we like a lot? We lobby for this as a profession. Got laws passed. What do you? Yeah. Whatever damage you cause is what you pay for. Your proportionate liability. So, you know, we're the auditors. Well, we're responsible for this portion of their loss, not for all of them. Okay? In states where it's joint and several liability, what do we got? All of it. You can see why we care, right? We'd rather just be responsible for our share of the loss, right? What we're responsible for. Okay, so it depends on the law and the environment. Okay, cool. All right, anyway. 4 sources of legal liability: liability to clients, liability to third parties under common law, and those third parties, the one that's really going to be able to come after us is called a what? Third party beneficiary, because we know who they are, right? Okay, and there are different levels in different states, by the way. Civil liability under federal security laws, you know, a group of shareholders sues us, and they can collect. And then criminal, government prosecution for us knowingly issued an improper audit report. Okay, so good things to know. Good things to know. All right, so the changing legal environment, financial statement users are more aware, maybe. You know, the SEC may be taking more actions. It ebbs and flows as the economy changes, politics change. Complexity in business drives, complexity in auditing and accounting functions, and then our litigious society. We like to sue each other in this country, so there's tons of it. Major contributors: when times are tough, auditing is harder. People are facing bankruptcy and they don't want to admit it. They lie in their financial statements. But what's really funny is when times are good, that tends to happen too. Too good or too bad. What happens when times are really, really good? Everybody's competing for investment dollars. What do you have to do to get those investment dollars? There's lots of things to invest in, not enough dollars to be invested. When times are bad, we feel like there's nothing to invest in, right? It's the other way around. And there's plenty of dollars. So the investor has the clout, right? In both cases, kind of. It's interesting. What happens at either end? If you've got a recession, tough economic times, people might lie to stay afloat, right? In their financial statements. What can happen in really good times? They lie to attract investment, to keep their interest rates low. It happens both ways. So at the peaks and valleys is really where we have the biggest problems. So you got to watch for that. And the economies go in cycles too, whether they're man-made or just natural, we don't know. But they tend to go in cycles. Every 10 years or so, things are going up and down and up and down. Watch the valleys and the peaks. That's kind of the point here. Okay? Willingness of CPA firms to settle out of court. Oh, won't you settle out of court if the legal fees are going to be more than you have to, than you can settle for? Yeah. But we as a profession settle out of court. So then people know we'll settle out of court. So what do? They sue us when they might not have otherwise. And we settle. So it does us in. We have insurance, right? Practitioner's insurance. Insurance company might decide I'd rather pay than fight that. We'll just pay it. And you might be the CPA saying we didn't do anything wrong. You know, you can defend that. Now it costs more to defend it to pay it. We're going to pay it. So to the extent that we do that, right? It's not any different than with automobile insurance. There are people, you know, that if you run into them, they're going to sue. They have a sore neck instantly. What do the insurance companies do if they don't ask for too much? Give it to them. What if they ask for too much? Fight. So it's a game almost, right? And we're in the same boat. So legal stuff is interesting in this country. Okay, so in the judges and jurors difficulty in understanding technical accounting and auditing matters. So, you know, we're left with a lot of money. These poor people lost all their money. They're victims. We're rich. So we get that. Okay. All right. We talked about business failure. We talked about audit failure, audit risk. Okay. What's the prudent person concept? Prudent person. What's a prudent person? Prudent, responsible, careful, reasonable, right? What a prudent person would do. Okay. So are we going to be held liable for people who make ridiculous decisions? Are we going to be held liable for people who don't read the financial statements? Usually not. Right? Usually not. Okay, so prudent person, you know, they tried. They tried to understand it. What we gave them wasn't understandable. Okay? All right, liability for the acts of others? How about that? That's that idea of joint and several, right? Okay. By the way, if you're in a partnership, are you responsible for the actions of your partners? Yes. You bet. Okay, absolutely. You realize that when Arthur Anderson folded that all the partners lost their partnership? Not just the ones that were on those audits that were apparently blind. Right? Okay. All right. And then privileged information, we talked about that, right? We don't have any CPA client privilege when we go to court. We have to testify, right? We can't accuse you unless it would incriminate us, and that's probably not a good defense. So we don't get privileged communication. We talked about those, right?
In that instance, why wouldn't a CPA firm always want to be either an LLP or an LLC?
They almost always do. And the question was, why wouldn't you be a limited liability corporation or a limited liability partnership if you could? In states where you can, you do. All the big four are. All the large firms are. Most small firms are too. Yes. Okay. To try to limit your liability. And by the way, years ago there was no such thing, right? You were either a corporation or you were a partnership. It wasn't all these things in between. Limited liability corporation, limited liability partnership. We lobbied for those state after state after state, right? And other professions did too, right? They have the same issues. Okay. So you're trying to limit your liability to some extent. It's not as good as the limitation of liability of a corporation. Okay, it's still better than better than nothing. Okay. Anyway, contract law, sure. Okay, we covered those. All right, here we go. Yeah, we did that. most common source of lawsuit against CPAs is from their clients. That would kind of make sense, huh? Okay. What are our defenses against client suits? So here we go. How can we defend ourselves? What's your defense that you could have? We could say, well, I wasn't engaged to do that. Lack of duty performed. That wasn't my responsibility. Okay. That one's pretty easy. If you got an engagement letter that says what you're going to do and they're suing you for something that you weren't supposed to do, you're probably in pretty good shape. Okay, so that's one. Lack of duty performed. It was outside the scope of the conduct. Okay, non-negligent performance. What does that mean? I proved I was not negligent. A little tougher, huh? But you can supply your working papers, right? And talk about the evidence you collected. Okay, contributory negligence. This one's helpful in a lot of states. What's contributory negligence?
You say that like the actions of the client like helped contribute to your actions.
Yeah, they really caused it, right? Or they were part of the cause. Yeah, maybe my audit was flawed, but a lot of their damages were because they didn't investigate the way that they should have investigated. Separate from having me do an audit. They can't blame it all on me, or they knew about it, right? They knew it wasn't a good investment. They went ahead with it anyway, and now they're trying to rely upon the audit. Okay, so contributory negligence. And absence of a causal connection, what would that be? They didn't rely on statements. Statements didn't have anything to do with the decision they made that cost them the money, right? Okay, so there's no causal connection. You try that. But these are our defenses. We're trying to establish these things. They're not, okay? Not their problem to defend us, I guess. Okay. All right. So what's the ultramares on page 121 at the bottom? This ultramares thing is just not very big, is it? So this is liability to the third parties. So the first thing we've got is the client coming after us, right? Second thing is third parties coming after us. Third parties who are what? Relying upon the financial statements, huh? Okay? So what's the we've got the ultramares doctrine, we got foreseen users, and we have foreseeable users. What's the ultramares? Who's covered by that? Primary beneficiaries. That's it. It's the primary beneficiaries, okay? So what's a primary beneficiary? Somebody we know, right, are relying upon it, especially if they're in the engagement letter, right? Okay. So what is this ultramares case? Look when it was, 1931 in New York. Okay, 1931 in New York. By the way, is this case still in effect? Yes, in a whole lot of states. This is precedent. Okay, common law precedent. Okay. So what was the ultramares? Ultramares versus Touche. Touche Roth. Deloitte Touche now, right? Touche back then. Okay. The creditors of an insolvent corporation, ultramares, relied on the audited financial statements and subsequently sued the accountants, alleging that they were guilty of negligence and fraudulent misrepresentation. Accounts receivable were falsified by adding $650,000 in receivables. Receivable, another item of over $700,000. The auditors alleged that careful investigation would have shown the $700 to be fraudulent. Accounts payable contained similar discrepancies. The court held the audit accounts had been negligent, but ruled the accounts would not be liable to third parties for honest blunders beyond the bounds of the original contract unless they were what? Primary beneficiaries. The court held that anyone who enters into a contract with an accountant for services can sue if those services were rendered negligently. So this is our lowest level of responsibility, ultramares doctrine. Okay? So over on page 123 at the top there, they show from the narrow to the broad, right? The primary beneficiary, third-party beneficiary is the ultramares case. And then the Credit Alliance versus Arthur Anderson reestablishes that, okay? Keeps it going. All right, so the auditor knows and intends the user will use the audit report. They're aware of the bank loan agreement that requires statements, for example. Okay, and then the rush factors in the green box at the bottom of 122, 1968, long time later. Where is this case? I kind of like these little things. The source down at the bottom. Where's that? Rhode Island. Oh. So real close to New York? Yeah. Okay. So in this one, the defendant auditor asked the defendant auditor to audit the statements seeking a loan. They issued an unqualified opinion on the statements indicating the company was solvent when in fact it was not. Plaintiff loaned the money, lost. The auditor's defense in this case was the absence of privity. What does that mean? They were not a third-party beneficiary, right? They could have found under ultimaris as a primary defendant choose to rely on the restatement of torts. So this is called restatement of torts. What they should have on table 5.2 up there next to primary beneficiary, I would write down third-party beneficiary. And then under foreseen user, I would write down restatement of torts. You'll see it both ways, okay? So restatement of torts is the Rush Factors case. So clear out in 1968, it took a long time. So it's reasonably limited and identifiable group of users who have relied on the auditor's work can sue, right, as a third party. Bank and trade creditors, and the auditor's aware the client's going to use the statements for that type of users, but they don't know which one. In the ultramares, you know which banker. Got it? In the Rush Factors, it could be any banker, but you know it's being used for a bank loan. Got it? Okay? So that's foreseen users. Okay? And it gets worse. What's the Rosenblum? What page is Rosenblum on? Look for it. Must have put a box somewhere for it, did they? No. They just put it in the text. It's a good case. Anyway, no Rosenblum. Okay, by the way, you know the names of these things. Know the names of these particular cases. There's only a few, but know the names of them. Okay? In the Rosenblum in 1983, and I think that one is actually New Jersey. This is funny, huh? Right around the same area. Okay? And across the nation, different states will either be using the ultramares doctrine, the restatement of torts doctrine, right, or the Rosenblum doctrine. Got the idea? Okay? So what Rosenblum is foreseeable users. So what does that mean? 1983. So even more recent. Our litigious society getting going here, right? What is this? An unlimited class of users that the auditor should have reasonably been able to foresee as being likely users of financial statements. Who might use financial statements? Any potential investor, lender, current ones. Who else? Unions, government. People are going to sell things to the company. People are going to buy things from the company, vendors and customers. Right? Wow. What do you mean, everybody? Yeah. Everybody and anybody who might use financial statements. So they can become a third party. All they have to do is show that they read the financial statements and rely on them. Okay? Got it? So this is a big deal, and they test you on this a lot. Okay? So Rosenblum. So I therefore I will. Okay? An unlimited class. So a trade creditor, for instance. You don't even know that they're using the statements. It doesn't matter. Everybody got it? So that's those guys. Foreseen, credit alliance, okay, foreseen, credit alliance reestablished ultramares, restatement of torts, right, and then here they are, and then foreseeable, Rosenblum and Happen, okay? Know those things, that's that table 5.2 there. Okay, cool. All right, when we get into the Securities Act, like we said, what's the 33 Act? Initial public offerings. And so Section 11 of the 33 Act defines the rights of third parties and auditors, okay? So this is pretty tight. This is the one that really squeezes us a little bit. And there are a few cases under this. You can see in 1968, the Escott versus Barcris on page 125, okay? What are our responsibilities? Oh, the 34 Act, what's that? Continuing reporting. Annual reports, quarterly reports, 10Ks, 10Qs, right guys? Okay. Rule 10b-5, and they'll tell you what does Rule 10b-5 apply to. It's the one that really applies of the 34 Act. Okay, they're typically called the anti-fraud provisions. You need to know this term too. What is scienter? Just in the SEC Acts, we don't use it under common law. Scienter is what? The auditors must have the knowledge and intent to deceive in order to be liable. This is big. What does that mean? We have to have scienter for them to come after us. The Rule 10b-5, right? For the fraud, be to you must have knowledge and intent to deceive. Do you have to have that under the 33 Act? No. Here's the deal. You are guilty until you prove yourself innocent under the 33 Act. Basically, that's the idea. Under the 34 Act, you are innocent until they prove you guilty. They have to prove that you had knowledge and intent to deceive in order to be liable for fraud under the 34 Act. Under the 33 Act, you have to prove that you're not liable for fraud. Got it? So it's much tighter, much tighter. Anybody, none of you guys have worked yet on an initial public office, right? Even a little bit. Did you get to touch one a little bit, to hang out a little bit with those guys? They do a lot of work, huh? It's really big work programs. I mean, they're just looking at everything, right? Extremely expensive audits, okay, for initial public office. Because we have huge liability, right? We have a lot of risk as an auditor. Audit risk jumps way up in a 33 IPO, okay? So this science is a nice thing. We like scientists, right? Because as long as you didn't have knowledge, right, and you didn't have the intent to deceive, you're okay, right?
Within 1933 and 34, which one of them is innocent until proven guilty?
34 Act.
34.
Yeah. The way to think about it. They're not going to ask you a question like that. But basically that's it. Okay? In most prosecutions in the US, you are innocent until proven guilty, right? You have a presumption of innocence. Under the 33 Act, it kind of flips. You've got to prove that you did a really good job. Okay? You got to prove that whoever's suing you screwed up, not you, basically. Okay? All right. Okay. The SEC and the Public Company Accounting Oversight Board for the sanctions to suspend practitioners, that's true. SEC has temporarily suspended a number of individual CPAs from auditing SEC clients. In fact, when Arthur Andersen got indicted, and they got indicted for shredding documents, obstruction of justice, it was not for any fraudulent activity, or it was not for substandard audits or whatever. You know, they were indicted for destroying documents, right? Shredding documents. And then later, the Supreme Court decided that that was an improper indictment. They should not have been indicted for it after the fact. But by then, Arthur Andersen didn't exist anymore. But what made me think about so didn't matter, right? But what made me think about this was that as soon as you're indicted, the SEC suspends your right to practice. So when they indicted Arthur Andersen for obstruction of justice, the indictment, right? They no longer could do audits until that indictment was cleared. And that was the end of the term. So we're always vulnerable, you guys. Don't go there on this stuff, right? As a profession. And there have been a number of firms that happened too. Okay, Foreign Corrupt Practices Act 1977, bribing a foreign official for the purpose of exerting business-related influence is illegal. So we got this act. And by the way, do companies do bribes? Yes. They disclose them in their financial statements, and they do not deduct them on their tax return. It's illegal to deduct on your tax return. It's also illegal to make the bribes, but we go ahead and do the bribes, and then we disclose them in our financial statements. You will actually see that. They won't call them bribes. They'll call them payments to foreign officials and things like that. But then it will not be deducted on the tax return. So we don't get a tax deduction for these expenses. Right? Because they're not legal. I'm not kidding. And in some countries, you can't do business unless you pay tax. So Boeing pays a lot of bribes, right? They just do. Companies like that. They're international business. Sad thing. But we would like to stop this practice or slow this practice down. And probably the 1977 Act helped with that. Slow it down some. Okay, Sarbanes-Oxley, we talked about this, right? Well, maybe not these pieces. The CEO, Chief Executive Officer, and the Chief Financial Officer are required to certify financial statements filed with the SEC. Right, guys? They actually have to sign now. They didn't used to have to sign. They'd sign a management letter that said that they gave us all the information, right? And still with non-public company audits, right? SAF's audits, Statement of Auditing Standards audits, they'll still sign a representation letter. We'll have to do that. We'll talk about that when we're talking about wrapping up audits. But the CEO and CFO actually certify now, just like the auditor does. Management reports on the effectiveness of internal controls. We talked about that before. Auditors provide an opinion on the internal controls. So the auditors give an opinion on the controls and an opinion for the purpose of the financial statements and on the financial statements. We already talked about that stuff, I think. Okay. What would give us criminal liability? So, all right. If there's a breach of contract, we didn't do what we were supposed to do, we're liable to the client only, nobody else. If we're negligent, we're liable to the client, and we're liable to either primary beneficiaries or other third parties. What are the two other third parties? By the way, primary beneficiary, what do we call the doctrine there? That's the ultramarys doctrine. You need to know that, okay? So that's what they're talking about there. In ultramarys states, we say. Okay, other third parties depending on jurisdiction, what are those two? Foreseen and foreseeable, right? What's foreseen? Restatement of torts, rush factors, okay? You have that stuff down, okay? And then what's foreseeable? Everybody else, which is called Rosenblum, right? Everybody got it? The Rosenblum case. If you've got that much, you're in pretty good shape on this. They'll ask you multiple choice questions about it as we discuss it, and then say maybe a little bit, okay? So, okay. For gross negligence, who are we responsible to? All of a sudden, any third parties, right? So negligence, what's the deal? They have to be a primary beneficiary or somebody we knew to use it, depending on the state, right? Or it was foreseeable. Anybody can if we have gross negligence. You just open yourself wide open, okay? And then liability to third parties under the 34 Act, yeah, probably so over here too. Okay, constructive fraud, recklessness, get a lot of yeses, don't you? Just like gross negligence, okay? And for fraud, you're going to be for anybody, okay? Everybody got it? Sarbanes-Oxley makes it a felony to destroy or create documents to impede or obstruct a federal investigation. Thank you, Arthur Anderson, for that. Right? So that's directly related to what they did. Okay. Auditor defenses. This is really good stuff to know. Table 5.4. Is that right? Yeah, there we go. 5.3 and 5.4. Yeah, over on page 128. Okay, so what's the deal? This is good. Get this down. I've seen essay questions. I've seen lots of multiple choice questions on this stuff. If I have lack of duty, where could I use that? Well, any place, right? Except the 33 Act. You can't claim you didn't have responsibility to that particular party. Non-negligent performance, that I did a good audit, that's always defense, right? Okay. Contributory negligence by the client, right? Well, as a third party, couldn't have contributory negligence, and it doesn't help you under the Securities Act, but it would under a client suit. Absence of causal connection can pretty much help you, but notice what happens under the Securities Act. What's the real thing that you can do to defend yourself? You did a good audit. That's about it. You got it. Other ones, client suits, quite a bit of stuff. Okay? So, good. How would you reduce the threat of litigation? What would be the best way? Think of the things you could list. If somebody asks you a question, what would you do to limit your legal liability? You're good on it. Yeah. Do professional care. Adequate training, supervision, all that stuff, right? Do a really good on it. Okay? Like the right evidence, documents, and all that. Okay? Also documentation, like evidence. Okay? And then, what else might you try to do? Have insurance. Be sure to have insurance. I'm not kidding. Really good idea. They say seek protection from non-meritorious litigation. So this is what we've been doing. What does that mean? We don't want frivolous lawsuits against us. We'd like to have laws that prevent people from doing frivolous lawsuits, or if they do, they have to pay. Get away with it. What else? We just went over a couple of them. What could you do? Form an LLP, an LLC. Absolutely. What else might you do? Which could limit your liability?
Have good customers.
What's that?
Have good customers.
Have good clients. Do that. Do a good audit for a good client. There you go. I like that. Okay, that's excellent. What else might you do? What do we do as a profession? We got rid of joint and several liability in lots of states and replaced it with proportional liability. That helps. Okay. So So they say improve auditing, seek protection from non-meritorious litigation, educate users about the limits of auditing. We always try that one. Do people think those statements are estimates, or do they think they're facts? The general public, they think they're facts. They think they're real numbers. I said this in principles. Do you think GE really knows how much cash they have? Give me a break. They don't know how much cash they have. They have an estimate of their cash. How about their receivables? They know how much they're going to collect on their receivables? How about warranty? Do you know what their warranty liability is? Give me a break. So therefore, you don't know the expense side either, the revenue side either. They're all estimates. Does the general public think those financial statements are estimates? Of course. Okay. And people in responsible positions don't think they're estimates, and I don't know how we get there. Do they think that we are verifying everything in the financial statements, at least subconsciously believe that? Or do they think we're looking at a really tiny sample and then relying upon that sample to make inferences and then give an opinion based on it? What do they think? We verified those statements. And they'll even say that. Well, you verified that number, right? Hello. I audited that number. I didn't verify anything, right? So it's how we talk about it too, though. Audited financial statements aren't the truth, are they? In our opinion, they faithfully represent, right? In all material respects. That's all we got. Okay. So, yeah, we oppose lawsuits, we educate people, sanction members maybe a little bit, lobby for change in the laws, and we have some rules. Here we go. Honest clients, qualified personnel, maintain, oh, I didn't mention that one, this one's big. Obviously, you'd say you follow the professional standards, but maintain your independence. Make sure you truly are independent. Sure. Okay. All right, and these are obvious, like we just talked about. Oh, this is good. This word in there. By the way, did I tell you guys yet? I think I did. If the word judgment is in an answer stem, look at that very, very carefully. Why? Everything is about professional skepticism. What's professional skepticism? Another one to always look for. I want to know that we really exercise our professional skepticism. What's professional skepticism? You're always questioning things. So that means you don't trust your client, right? No, they wouldn't be your client if you didn't trust them. You do trust them. You maintain professional skepticism. So if I was auditing you, I would believe you, but I would be skeptical. I'd want proof. I'd want evidence, right? If I didn't believe you, I would withdraw from the gate. I believe you, but I want evidence, okay? So professional skepticism is questioning, right? It's challenging. It's not taking sides, though. You're independent, therefore you're objective. You're not at your client's side, you're not at the financial statement user's side. You just want everybody to tell the truth, right? Okay? So professional skepticism is you don't quite trust anything or believe anything without having evidence. It's really scary for your life, you guys. An auditor, and you're kind of, you don't really believe anything you hear, anything you read. Without some support behind it, right? Besides, I don't think there are any facts, there's just evidence. There are facts. Give me a break. If somebody says they know the facts. No, their perception of facts are different than somebody else's perception of facts. You ever seen a political debate where they're talking about the same stuff? Come on. They're talking about the same facts, right? Whatever happened, happened. Have you ever watched a football game with a friend where they're rooting for the other team? If you have any friends that root for different teams, a U of L and a UK person sitting right next to each other watching a basketball game, what happened during the game? Do they have the same facts? No, they're both biased, right? So they can't make an objective decision about what happened, and I wouldn't want to be the person sitting between them making the objective decision, disagreeing with one of them, right? Maybe. Okay, that's kind of where we are. Okay, so we talked about this. Oh, this one's good. Legal counsel. When you hire legal counsel, make sure they are legal counsel that have expertise in the area, right? Really good idea. That they had worked on accounting losses. So anyway, and then limited liability, you talked about that. Okay, let's look at, question. Guy with the question mark head. Let's look at a couple of other things. There's some cases in here. Some cool ones. The ones, we didn't talk about 1136 tenants. Oh, gosh, put it out. 1136 tenants versus Max Rothenberg. I love this one, 1967. What's this case about? on page 120, 55 3. What's that one?
About whether or not what you were engaged in.
What you're
What you were
engaged to do.
hired to do.
That's it. Yeah. So what were they engaged to do? They're charging $600 a year, and the tenants recovered $235,000. Lovely, huh? This is a tenants association, and somebody stole the money, and there were missing invoices, and the accountant was aware there were missing invoices but did not investigate. Wow. But that's not the worst thing. What's the worst thing that they did? They had no letter of agreement with the client. So what were they really doing here? It was unaudited at that time, we would have called it. Now we call it a compilation, right? We're compiling the statements form. We just let the statements be based on their information. What did the court decide, seeing that there was no engagement letter? That you must be doing the highest level of service that accountants do. So therefore, what were they engaged to do? An audit. So then, if there are missing invoices and you're aware of it, what do you think? You didn't do a good audit, you're guilty. They lost. Even if it had been a compilation or an unaudited engagement, when you run across some information, you have an obligation to investigate what you did find. You're not auditing, you're not collecting evidence, but you are aware that something's wrong. Are you obligated to investigate that and report it? Yeah. So really, even if it's been a compilation, they probably would have been guilty. Evidence, right? Even if it was unaudited, they might have been guilty. But the big thing in this case was the court didn't know what their engagement was for. It gets worse. When I was first working at Dwyer, Pittman, and Colson, I'd go out on engagements that were unaudited, compilations and reviews that just started. They were unaudited engagements, and Dwyer was his name. He was the guy that started the firm. He was this old guy, alcoholic. We'd go to CPE seminars together, and he'd fall asleep for the first half, and then he'd leave because you got counted if you were there. I'm not kidding. You know, that's how he did his CPE, getting professional education. It was awful. And I was taking over he was retiring that year, and I was taking over all of his engagements. He would actually sit and talk with the client and discuss the audit when it was a compilation. I'd say, Joe, it's not an audit. And the client would look at me and say, I know it's not an audit. Don't prove that it's a compilation. He'd call it an audit. He'd say he was examining things, right? You don't do auditing procedures on a compilation or a review, or you have now done an audit. If you collect evidence, you're auditing. Got it? So you never collect evidence in a review or a compilation, ever. Unless something comes to your attention and you're investigating that, like this would have been. Then that's okay. Right? And you don't call it an audit, you don't call it an examination, you're not giving opinions, you keep it real separate. And this is a lot of the reason. So what did this lead to? Engagement letters. We do an engagement letter for everything. If you're going to do a tax return for somebody, you say you're doing the tax return and I am not doing the audit. I'm not kidding. If you're doing a compilation, you say I am doing a compilation, not a review, not an audit. And we do every single time. You look at these engagement letters, you think, what the hell are they doing? They came out of this one case. Okay? So, and I think it's a good idea too. Tell the client what you're going to do, right? Why not? If you don't have an agreement with somebody and you start doing work for them, I think they're crazy. So, have an agreement. So that's what that is. Okay, it's a fun one. Look how much they lost. Wow. Went through the appeals process and everything. Let's see. There's another one. What's the Senko and Seidman liability to clients? Massive fraud. What's that one about? I don't know that you get tested much on this one. But it's interesting. 70 and 75, ultimately including top management, were involved in the fraud. In the CPA firm, what happened with them? Settled out of court in a class action suit paying $3.5 million. Okay, the new management brought a second suit. Primary defense, right, was that a diligent attempt was made on the part of the auditors to follow up on the fraud and didn't find everything. Seventh Circuit Court concluded the CPA firm was not responsible in this case. The wrongdoings of the new management were considered an appropriate defense against the charge of breach of contract, negligence, and fraud. Right? So they contributed to it, right? because the management was involved, the CPA firm was duped in this case and was not considered to be negligent. So that's kind of an interesting one. So we win sometimes, we lose sometimes. I think it's really the biggest point of that. Escott and Bar Chris is real famous. This one's real famous. Escott and Bar Chris. This is under the 33 Act. What's this one about? 33 Act is what? Oh, I'm on page 125, sorry. 125. This is the famous one, I guess, under the 33 Act, one of the first ones. So they filed an S1 registration statement, right? They're gonna issue stock with the SEC in 1961, convertible subordinated debentures, right? So it's the Act of 33, initial public offering. Okay, they filed for bankruptcy and they sued. The most significant issue in the case, especially to audit staff personnel, was the matter of the review of the events subsequent to the balance sheet, called an S1 review. And they didn't do a proper one, so this is where the S1 review came from, that we actually follow it. Okay, or audit it, I guess. The court concluded the CPA firm's written audit program was in conformity with auditing standards in existence at the time. However, they were critical of the auditor conducted the review, inexperienced in audits of construction companies for the failure to appropriately follow up on answers by management. Okay, so accountants should not be held to a higher standard than that recognized in the profession. I do not do so here. Right? The review did not come up to that written standard. It did not take steps that they should have in the written program. Did not spend adequate amount of time on the task of this magnitude, and this one's big. Most important of all, he was too easily satisfied with glib answers to inquiries. You ask a question, and they give you an answer to get rid of you, don't go away. My thing was always, I don't understand, I'm just kind of slow, I'm sorry. After a while, they started getting mad when I told them how slow I was, that they had to explain it to me again. If I don't understand, I don't understand. You got to explain it until I do. And they'll try to, by the way, people try to get rid of you because they're just so busy. Yes. But they're still trying to get rid of you. You got to have the answer. So don't go back to your senior. Anybody have this experience? You go back to your senior with some stupid answer the client gave you that couldn't possibly be right? Because you went and asked a question, and they have you doing that, right? Go ask the client. Go ask the client. You're auditing. Don't ask me. Ask them. What are you going to say? You confirmed it with me or something? Might as well say you confirmed it with God. You know, that's always my line. You know. I've actually seen people writing work papers that they asked me. You know, I asked the manager, I asked the senior, whatever, you know, and they write it down in the work papers. You get in big trouble for that one. You know, that's not auditing. You're asking the client, right? But what if the client gives you a ridiculous answer? Follow up, follow up, follow up. Go to the senior and say, was this answer all right? You know, and they'll say no, and then they'll go with you. Nobody's had that experience yet? Yeah, okay. And the senior will go with you, won't they? And they'll make you go too. And then they'll ask the question, and you learn how to ask the question so that you get an answer. Sometimes they're just jerking your chain. They used to work in a Big Four firm, and you're doing an internship with a Big Four firm, and they just like to, you know, screw with you a little bit, you know, give you a hard time. So they'll give you ridiculous answers and send you away. You'll write them down. You know, so you got to watch for that too. So, but the glib answer is really a big deal. Okay. So anyway. This is not to say that he should have made a complete audit. So anyway, there were dangers, and they should have asked. CPA firm was found liable in the case on the grounds that they had not established due diligence under the 33 Act. So pretty serious one. Hochfelder, how about that one on figure 5-7? Hochfelder. What's the deal with this one? Hochfelder versus Ernst, another famous one. This is the 34 Act. Now in the 34 Act, what's the deal? Yeah, continuing work. Yeah, you bet. Annual reports, quarterly reports. Okay, so what's this thing? Auditor's liability for detecting fraud perpetrated by the president of the company, right? Okay, the client's firm. The client firm. Okay. Fraudulently convinced certain customers to invest in accounts, and, you know, then they stole funds. Okay. So what happens? Ernst and Ernst at the time, now Ernst and Young. Failed to conduct a proper audit that should have led them to discover this mail rule in the fraud. Okay. The mail rule was what? All correspondence with customers were made solely to May. Second checks of the customer were drawn payable to May, and because of the mail rule that he imposed, such mail was opened only by him. Should you know about things like this? Mail comes in, it can only go to one particular person. A little weakness in internal control here, you think? We'll talk about internal controls later. Who opens the mail? Who receives the mail? Usually a receptionist. Mailroom or receptionist? Really? Low level. Who controls it? They do. Who opens it? Depends on the organization, but probably a lower level assistant in the department that's receiving the checks. And what do they do immediately? They stamp every single check for deposit only on the back. And it's no longer a negotiable document. It can only go to that bank. You're done. Then it goes to people who might use it for other things, right? Like accountants. We don't touch anything. Why? We separate the money from us. How easy would it be to embezzle if they actually let you handle the money and then record the transactions too? So we separate that stuff. That's why small businesses have a really rough time. They don't have enough employees to have good internal control. So we'll talk about that. So this was horrible, right? Okay, so the Court of Appeals, what happened was the district court dismissed the action, right, on the thing, did not resolve the issue, and then a Court of Appeals reversed the court, held it was one breaches the duty of inquiry and disclosure, owed another it's liable for aiding and abetting a third party's violation. Rule 10b-5, if the fraud would have been discovered and prevented had the breach not occurred. So their poor audit was made them party to the fraud. Got the idea? So this is a big one, all right? The court reasoned that Ernst had a common law and statutory duty of inquiry into the adequacy of their internal control. So this is a lot of where our evaluation of internal control came from, okay? And it became part of the deal. So anyway, Sorota and Solitron, another one under 34 in 1982. I haven't seen that one tested, but same sort of idea, right? The Court of Appeals stated that proof of recklessness may meet the requirements of the intent of 10b-5, okay, and didn't address in this particular case, but let's see. U.S. versus Anderson, this was good. Criminal liability on page 129, figure 5.9. So you can actually have criminal liability under which acts? Primarily the 33 Act, right? Okay. So in this one, though, this is before, obviously, Sarbanes-Oxley. Charged Anderson with destruction of documents related to the firm's audit of Enron. Guess what happened? Enron collapses, and during the investigation that the SEC was making, Arthur Anderson shredded documents. Dumb? Right? By the way, they shredded documents in accordance with their normal practice of shredding documents. We already talked about all the review points, right? What do you do with them? You destroy them, right? Destroy the computer record. Shred them when they used to be on paper, right? Shred them. What did you run here? There was an SEC investigation going on, a Justice Department investigation, and they went ahead and shredded documents that they would have ordinarily shredded anyway. What is the appearance? You were shredding documents to hide evidence. Nobody knows if they were shredding documents to hide evidence or they were just shredding. But they had some emails going back and forth between Chicago and Houston. The engagement was in Houston. Head office in Chicago, where an attorney in Chicago told them they should probably go ahead and shred documents. With that meeting, right? So we'll never know what they shredded, of course, okay? Anyway, so yeah, this was pretty ugly. They had this huge loss, but the bad thing for Arthur was they ceased to exist. So anyway, enough on this crap. You should be able to